try and get through as many as we can. And this first one that we have, Ryan, this dropped in during your segment. Again, it did also, a similar question dropped in during your segment, Tony. So it's open to the pair of you first, and if either of our other panelists want to chime in as well, they're more than welcome to do so. But Ryan, in non-statutory claims, like as Tony also discussed, how might a complainant demonstrate actual substantial injury to the domestic industry?
Yeah, thanks. That's a good question, and it's something that I've definitely dealt with in the past. And off the top of my head, I think the commission has indicated that there are a number of ways which a complainant could show actual substantial injury. For example, I think you might want to look at the respondent's volume of imports and their penetration into the market. Maybe the complainants experienced a reduction in market share, or maybe the respondents experienced an increase in market share. You could also consider whether the complainant has lost sales or customers or opportunities. I think the commission's identified that you could also look to see if there's been underselling by the respondent. Maybe the complainant's able to show that it's experienced a decline in production or profitability or sales, kind of dovetails with that other one that I was describing. And finally, I think I even mentioned this in the presentation, but the commission's indicated that you can consider whether there's been harm to the complainant's goodwill and reputation, such as evidence that maybe poor quality of infringing product led to customer confusion or a loss of reputation. So those are some of the ways that you can try to establish actual substantial injury.
That's very helpful. And I'll just add also price erosion is another element that should be focused on. And also practitioners should be aware and complainants should be aware of the differences in the law. I mean, obviously in the antitrust violations cases I mentioned, the commission right now is requiring parties to establish antitrust injury and plead antitrust injury in their complaint. So you really need to focus on the legal aspects of the type of injury to be pleaded and the harm to the domestic industry that needs to be pleaded as well.
Thank you so much, Tony. This next question, it dropped in during your segment, so perhaps you want to take the lead on this, but it is also open to our other panelists as well. But why do you believe that there's been an increase in Section 337 investigations when it comes to the involvement of trade secret misappropriation?
Well, I think, again, to reiterate, I think there's several reasons for it. And Tian Rui, the Federal Circuit decision in that case was actually a good springboard for that increase in the number of trade secret misappropriation investigations for a number of reasons. I'm going to start this time. I ended with it last time. But the powerful injunctive remedy in the ITC, there's been a sequence of cases where anywhere from a 10 to a 25-year exclusion order has been issued in these cases. And again, I advise practitioners to follow the Allergan case, which is we're expected to receive an ID from Judge Shaw tomorrow in that case. So that's something to follow and see what recommended exclusion order he recommends in that case, and what length of an exclusion order potentially ultimately issues if the commission decides to issue an exclusion order in that case. And the other factors are, as I mentioned, domestic industry requirement. You don't have to plead technical prong of domestic industry has been met. In trade secret misappropriations, you just have to prove that there's been an injury to the domestic industry, but that industry does not have to practice the trade secrets. And the third point I want to mention is the fact that the commission has extraterritorial jurisdiction over acts that occur abroad, and therefore, unlike district courts, it has the ability to initiate investigations over acts that purely occur abroad because of that extraterritorial jurisdiction, and based on the fact that its jurisdiction is with respect to imported products. And so imported products that are based on misappropriated trade secrets that occur abroad are subject to ITC jurisdiction, and you may not get jurisdiction in federal district court over those actions.